Please be seated. The Court meets this morning under Article 74, Paragraph 3 of the Rules of Court to hear the single round of oral argument of the Cooperative Republic of Guyana on its request for the indication of provisional measures in the case concerning the arbitral award of 3 October 1899, Guyana versus Venezuela. And I now invite Mr. Paul Reichler to take the floor. You have the floor, sir.
Madam President, members of the Court, good morning. As always, it is an honor for me to appear before you, although I wish on this occasion it had not been necessary for me to be here, or for these hearings to be held, or for Guyana to be compelled urgently to seek the Court's assistance in preventing incalculable and irreparable injury to the very rights that are at issue in this case, including its right to the integrity of its own national territory. Nothing less is at stake, or else Guyana would not have imposed on the Court's valuable time with this request for provisional measures. Guyana's written request for provisional measures is before the Court, and its contents need not be repeated aloud this morning. I will simply highlight some key points to put Venezuela's impending referendum in context and further demonstrate why it portends irreparable prejudice for Guyana, especially in the form of irrecoverable loss of the territorial rights that are the subject of these proceedings. I begin with this map. This is a map of Guyana with its Essequibo region shaded. As the Court will recall, this is the territory that was determined to belong to British Guyana in the unanimous arbitral award of 3 October 1899. The land boundary between British Guyana and Venezuela, fixed by the 5 arbitrators, is shown in the thick black line. This is the same boundary that was subsequently demarcated by a joint commission and formally agreed to by Venezuela in 1905 and then ratified by its National Congress. It is the same boundary that Venezuela consistently recognized as the international boundary with British Guyana without interruption and without formal protest until 1962. This is the territory that is now claimed by both parties to these proceedings as a result of Venezuela's belated challenge to the validity of the 1899 arbitral award and its resurrection of the same territorial claims that were rejected unanimously by the 5 arbitrators many decades earlier. This is the territory, the rights to which will be finally determined by the Court in its judgment on the merits in this case. In particular, and for the purposes of the request for provisional measures, Guyana's rights to this territory will be determined in the judgment on the merits. These are the rights that are at urgent risk of irreparable prejudice from Venezuela's impending actions. Venezuela has made clear that the referendum it plans to hold on 3 December is for the purpose of obtaining a popular mandate to carry out actions that it has already decided to take. What are these actions? According to public statements by Venezuela's highest officials, they include the definitive and final rejection of the 1899 arbitral award, the rejection of the Court's jurisdiction in defiance of its judgments of 18 December 2020 and 6 April 2023. The refusal to recognize the court as the means of settlement of its territorial dispute at the heart of this case. The annexation of the disputed territory and its incorporation into Venezuela as a new Venezuelan state. The granting of Venezuelan citizenship and national identity cards to the population. And the defense of the territory against Guyana's assertion of its rights. Venezuela has made clear that the purpose of this referendum is not merely to assess public opinion. It is to obtain popular support for decisions that the government has already made and a license to act on those decisions. This is how President Nicolás Maduro explained the referendum on 23 October. Quote, "It is the first time that all the political, diplomatic, legal, historic, territorial arguments are given to our people so that we can take a collective decision as a country." The nature of that collective decision is revealed by the questions themselves, both in their form and their content. They are far from neutral, as would be the case for a true test of public opinion. Madam President, it does not take an expert on public polling to see that these 5 questions have been deliberately crafted so as to leave no possible outcome other than an overwhelming mandate for the government to take actions that it has already decided upon. And this is obvious in every single question. Here is the first one, quote, "Do you agree to reject, by all means, in accordance with the law, the line fraudulently imposed by the 1899 Paris Arbitral Award that seeks to strip us of our Guyana-Essequiba?" Is there any doubt that the Venezuelan public, whether or not they have ever heard of the 1899 Arbitral Award or know anything about its contents, will reject something said to be fraudulent that strips Venezuela of our Guyana-Essequiba? But where will this inevitable rejection of the arbitral award leave the court? Will there be any role left for you to decide upon the validity of the award after the referendum produces an overwhelming popular mandate to reject it and the boundary it fraudulently imposed so that Venezuela can take back the territory that was stripped from it? Well, in case there is any doubt, Venezuela provides the court with the answer in its third question. Quote, "Are you in agreement with the historic position of Venezuela of not recognizing the jurisdiction of the International Court of Justice to resolve the Guyana-Essequiba territorial controversy?" There is no doubt that Venezuela's intention here is to produce another overwhelming popular mandate, this one to endorse its rejection not only of the 1899 arbitral award, but of the court, and whatever judgment you may ultimately issue on the merits of this case. President Maduro himself has made this abundantly clear in this Venezuelan government video.
Porque el día de hoy Guyana metió un recurso temerario que la Corte Internacional de Justicia, supuestamente de acuerdo a la pretensión temeraria, saque una resolución suspendiendo el referéndum consultivo constitucional de Venezuela del 3 de diciembre. Ya vamos a responder, porque para nosotros es muy claro que en el caso de la controversia de la Guayana Esequiba, jamás Venezuela ha reconocido y jamás reconocerá a la Corte Internacional de Justicia como instancia para la atención o resolución de este tema. Jamás. Jamás.
Quote, we are going to respond because for us it is very clear that in the case of the dispute over the Guyana-Essequiba, Venezuela has never recognized and will never recognize the International Court of Justice as an instance for the attention or resolution of this matter. Never. Never. How can the President of Venezuela declare a month before the referendum is held that the outcome will be a rejection of the court as a means for resolution of the territorial controversy with Guyana? Have they already counted the votes? Or is the result so obviously preordained that the referendum is no more than a rubber stamp, a device to obtain popular backing for a policy decision that has already been made at the highest level of government? And what of Guyana's rights, including its rights under the 1966 Geneva Agreement, Article 4.2, and the decision of the Secretary General that the controversy over the validity of the 1899 arbitral award is to be resolved by the court? According to President Maduro, this right, which goes to the very core of these proceedings, will not only be irreparably injured, it will be permanently extinguished. Jamás, never, never to be respected. The same tragic fate awaits Guyana's right to the territory comprising its Essequibo region, more than 2/3 of its national territory, as question 5 makes clear. Quote, are you in agreement with the creation of a Guyana-Essequiba state and for an accelerated plan to be developed for comprehensive attention to the present and future population of that territory that would include, among other things, the granting of Venezuelan citizenship and identity cards in conformity with the Geneva Agreement and international law, consequently incorporating said state on the map of Venezuelan territory? The outcome intended by the Venezuelan government could not be clearer. The collective decision called for here involves nothing less than the annexation of the territory in dispute in this case. This is a textbook example of annexation. What else would we call the creation of a new Venezuelan state comprising the territory, this territory, the conferral of Venezuelan citizenship on its inhabitants, and the incorporation of the new state into Venezuelan territory? What would be the effect on Guyana's rights in that territory, the rights it seeks to confirm in these proceedings after the annexation of the territory by Venezuela takes place? How likely is it that Venezuela will ever reverse its annexation and accept Guyana's sovereignty over the territory, especially after it rejects the court as the means for resolution of this matter? Madam President, I wish I could say that annexation by one state of another state's territory is a historical footnote consigned to the period before World War II, before the creation of the United Nations, and before the adoption of a charter that has Article 2, Paragraph 4 as one of its principal foundations. Unfortunately, Unlawful annexation is an infectious disease like polio, which was once thought to have been eradicated, but has reemerged, among other places, in Kuwait 30 years ago, and more recently in Ukraine and the occupied Palestinian territories. What is different here is that the court has jurisdiction and still has enough time to stop it from occurring because the intended annexation has not yet taken place. It awaits the holding of the 3 December referendum. And that is the reason Guyana submitted its request for provisional measures and asked the court to hold hearings on it at the earliest possible date. Unless the court indicates these measures, the contents of which Professor Plea will more fully describe, there can be little doubt that Guyana's rights to the Essequibo region, should the court find that it has such rights in its judgment on the merits, will be irreparably prejudiced, if not lost forever. Venezuela has made clear that after the referendum, it will count on its armed forces to defend its annexation of its new state of Guyana-Essequiba. Military preparations have already begun. This is a map which shows the location on the Venezuelan side of the international boundary, where Venezuelan armed forces are now constructing a military airfield to carry out the government's plans for the Essequibo region of Guyana. And this is an article from a Venezuelan publication quoting Colonel Juan Gutierrez Ortiz that Venezuela is building a landing strip that, quote, will serve as a logistical support point for the integral development of the Essequibo. And next is a video of the actual construction work, concluding with this statement by Colonel Gutierrez Ortiz, as posted on Twitter by the chief of the Operational Strategic Command of the Venezuelan Armed Forces.
Ok, entonces vamos a ir detrás de la máquina, ¿verdad? Nosotros vamos recogiendo todo lo que va dejando las máquinas. Los señores van adelante con la máquina, nosotros en la parte de atrás. ¿Estamos claros? Pues vive mi comandante, coronel Juan Gutiérrez Ortiz. Me encuentro en el área de desarrollo integral La Camorra, en la construcción de la pista de aterrizaje que servirá como punto de apoyo logístico al desarrollo integral de Essequibo.
Quote, I am in the area of integral development of La Camorra in the construction of the airstrip that will serve as a logistical support point for the integral development of the Essequibo. Venezuela's Minister of Defense, General Vladimir Padrino Lopez, has posted a series of videos and tweets emphasizing the readiness of the armed forces to intervene directly following the referendum on 3 December to assert and defend Venezuela's territorial claim to the Essequibo region. As shown in this video.
Así que esto es un asunto que no es de derecha o de izquierda, no es un asunto de ideología política, es un asunto de sentimiento nacional, de gran sentimiento nacional. Fuerza Armada Nacional Bolivariana, al combate. Fuerza Armada Nacional Bolivariana, a la defensa de nuestra Venezuela y de nuestra integridad territorial. Fuerza Armada Nacional Bolivariana, vamos al combate, vamos a la lucha y vamos también a la victoria. El sol de Venezuela, el Essequibo, venceremos.
Quote, National Bolivarian Armed Forces to combat. national Bolivarian armed forces to the defense of our Venezuela and our territorial integrity. National Bolivarian armed forces, let's go to combat. Let's go to the fight. Let's go also to victory. The sun of Venezuela rises in the Essequibo. The Essequibo is ours. We shall prevail. Next is another tweet from Venezuela's Minister of Defense on 24 October. Quote, "We are absolutely determined to recover our Guyana Essequiba. We have ample historical and legal reasons. No imperial power will be able, against the will, conscience, and wisdom of an entire people who, in a consultative referendum, will say 5 times in response to the 5 questions, yes, Essequibo is ours." As the public declarations of Venezuela's highest civilian and military leaders demonstrate, the upcoming referendum is not a purely internal matter, but an integral part of Venezuela's plan to breach its most solemn international obligations. By rejecting resolution of its territorial dispute with Guyana by the court, by ignoring and defying the court's judgments on jurisdiction and ultimately the merits, and by resorting to unilateral action to resolve the dispute by seizing and annexing the entirety of the very territory that is the subject of these proceedings, and by extinguishing Guyana's hopes of ever enjoying its rights to that territory. The referendum may consist of words, but they are words intended to lead directly to actions that have already been planned and announced and that Venezuela stands ready to carry out. I turn to the 3 questions posed by the court on 10 November. Since they involve matters of Venezuelan law and procedure, our colleagues on the other side may have their own answers to these questions. For Guyana's part, it understands 1, that the Venezuelan Supreme Court upheld the constitutionality of the referendum in a ruling issued on 31 October. 2, that the government intends to go forward with the referendum as scheduled on 3 December. And 3, that the results will not be legally binding under Venezuelan constitutional law. However, whether the results are legally binding or not, the government has already declared its intention to act in accordance with them and to use them as a springboard to enforce Venezuela's purported rights in respect of the territory at issue in this case, to the exclusion of Guyana's rights in the same territory. The government has already made this clear, including in a communique issued on 24 October. Quote, "The National Assembly of the Bolivarian Republic of Venezuela, in full exercise of its powers, has decided to consult the people of Venezuela on the master lines of legal, diplomatic, and political actions in order to assert the legitimate rights over the territory of the Guyana Essequiba. The results of this consultation will thus be an assertion of Venezuela's so-called legitimate rights. To reject the 1899 arbitral award without waiting for the court to rule on its validity, as per question 1. To reject the court itself as the means of settlement of this dispute, as per question 3, and to incorporate the disputed territory into a newly created Venezuelan state, as per question 5. These are Venezuela's publicly declared intentions. These are the actions that Venezuela is preparing to carry out. The referendum does not need to be legally binding to serve its intended purpose as an instrument to generate public enthusiasm in support of these internationally unlawful actions. Madam President, as Guyana has shown in the written request for provisional measures that it submitted to the court on 30 October, all the elements necessary for the indication of provisional measures are present here. There is no doubt about the court's jurisdiction, let alone prima facie jurisdiction, following the judgment of 18 December 2020, confirmed by that of 6 April 2023. There's no question about the plausibility of Guyana's rights to the territory at issue here. Its rights are based on a unanimous arbitral award, a demarcation agreement signed and ratified by Venezuela, and Venezuela's long-standing acceptance and acknowledgement that the territory belonged to British Guyana. Nor can there be any uncertainty about the irreparable prejudice that would befall Guyana's rights if Venezuela were to unilaterally reject the arbitral award, reject and ignore the court and its judgments, and proceed to formally incorporate the disputed territory into itself. Urgency is shown by the impending referendum, to be held less than 3 weeks from now, which would be the trigger for the execution of Venezuela's annexationist plans, and by the preparations of the National Bolivarian Armed Forces to secure Venezuela's claim to the territory. As the court has explained on various occasions, quote, the condition of urgency is met when the acts susceptible of causing irreparable prejudice can occur at any moment before the court makes a final decision on the case. All the requirements for the indication of provisional measures are therefore satisfied here. Madam President, before I ask that you call Professor Plea to the podium, for the sake of completeness, I would like to briefly address the 2 referendum questions that I have not thus far mentioned, questions 2 and 4. Question 2 asks, do you support the 1966 Geneva Agreement as the only valid legal instrument for reaching a practical solution satisfactory to Venezuela and Guyana in relation to the controversy over the Guyana-Essequiba territory? Context is critical here. Venezuela continues to swear by the Geneva Agreement, but not the agreement as written or as interpreted by the court. According to Venezuela, the 1966 agreement requires the party to resolve the controversy only and exclusively by negotiation and by no other means. This is directly contrary to what the court ruled in its judgment of 18 December 2020, and it ignores completely Article 4.2 of the agreement, which is the basis of the court's jurisdiction to resolve this controversy. Question 2 appears to have been designed by Venezuela to promote the fiction that it is committed to the Geneva Agreement and that Guyana is not, when in fact the reverse is true. Professor Plea will have more to say about this, and he will explain why Guyana does not believe there is need for a provisional measure specifically addressed to this question. Question 4 asks, quote, do you agree to oppose, by all means, in conformity with the law, Guyana's pretension of unilaterally making use of a sea, pending delimitation, illegally and in violation of international law? This question and the inevitable answer pose a grave threat to Guyana's economic development activities in the maritime area adjacent to the Essequibo coast. Venezuela has been issuing increasingly harsh and menacing statements against Guyana over these activities. This is a communique issued by Venezuela on 19 September. It says that, quote, finally, the government of the Bolivarian Republic of Venezuela warns all the companies that participate in the illegal bidding process convoked by Guyana that it will apply all the necessary measures to prevent the illegitimate exploitation of the natural resources that belong to our country. This is a Venezuelan communique issued on 25 October. It accuses Guyana of, quote, the illegal, abusive, and arbitrary conduct of disposing of a territorial sea still pending delimitation. And it says that, quote, this behavior threatens the stability of the region fed by Guyana's stubborn association with the interests of the United States Southern Command. 3 days later, on 28 October, another communique stated, quote, Venezuela denounces once again the buy-off of the entire Guyanese leadership by ExxonMobil, a transnational corporation that designs plans to threaten and attack the Venezuelan people and steals the resources that belong to them. Even more ominously, Venezuela's Minister of Defense, General Padrino Lopez, has posted a series of tweets threatening armed intervention against Guyana and its licensees in these maritime areas. This is one of them, posted on 13 October. The Cooperative Republic of Guyana the Cooperative Republic of Guyana has granted concessions to transnationals in blocks that penetrate into spaces undoubtedly Venezuelan. Now, thanks to the forcefulness of the National Bolivarian Armed Forces in defense of our sovereignty, they can be sure that they will get a proportional response, timely and legitimate, to defend what is ours. Long live Venezuela. This is a direct threat to Guyana's rights in the maritime area adjacent to its coast. However, Guyana's request for provisional measures does not seek the court's protection of these rights. This is because it cannot, as a result of the court's judgment on jurisdiction of 18 December 2020. In that judgment, as you will recall, the court decided unanimously that it has no jurisdiction, ratione temporis, over any claims arising after the entry into force of the 1966 Geneva Agreement, including the claims Guyana made in its application of 29 March 2018 concerning Venezuela's interference with its economic development activities in the sea adjacent to the Essequibo coast. As Professor Plea will explain, this is the basis on which Guyana has refrained from asking the court for a provisional measure specifically addressed to question 4 and the threats Venezuela has made to interfere with its activities in the sea. Because the parties' maritime dispute arose after the entry into force of the Geneva Agreement and is not covered by the dispute resolution provisions of Article 4.2, Guyana has proposed to Venezuela that their respective maritime claims, including delimitation of a maritime boundary, be resolved peacefully and definitively in bilateral negotiations or by impartial international adjudication or arbitration, whichever Venezuela prefers. This could include a new case before the court addressed to the parties' maritime claims, to which they both could give their consent. Guyana's proposal is set out in its note verbal to Venezuela of 15 August 2023, which is in your judges' folders this morning. Regrettably, Venezuela has not accepted Guyana's proposal for the peaceful settlement of the maritime issues that divide them, and now, as you have seen, it is threatening to press its own claims by the use of force against Guyana and its licensees. Guyana's willingness, indeed its eagerness to engage directly and diplomatically with Venezuela on the maritime issues, stands in contrast with its unwillingness to do so on the land issues, particularly its unwillingness to agree to bilateral negotiations on the validity of the 1899 arbitral award or the settlement of the land boundary. Unlike the maritime issues, the court has ruled that it has jurisdiction over the land issues and that it will resolve them in its judgment on the merits. Guyana will do nothing to undermine these proceedings or the judgment of the court. It views Venezuela's ongoing insistence on a bilateral dialogue to settle the land issues as a ploy to evade the court's jurisdiction, diminish its authority, and trap Guyana in an endless negotiation without possibility of success. As the court is well aware, a prolonged and fruitless negotiation has already taken place in the form of a 27-year good offices process managed by the Secretary General. Guyana committed itself to that process for more than 2 decades and participated in it in good faith. It was because of the inability of that process to achieve any progress toward a settlement over more than a quarter century that the Secretary General in 2018 declared it a failure and chose the court as the means of settlement of the parties' territorial dispute. Guyana is fully committed to having the court settle it and will continue to resist Venezuela's entreaties to abandon the court in favor of other forms of settlement. Madam President, it is notable that Venezuela's 5 referendum questions pay the same kind of homage to the law or international law as they do to the Geneva Agreement, which is to say, to Venezuela's twisted reading of both the law and the agreement. How would it be possible, for example, to, quote, reject by all means in accordance with the law, as in question 1, the boundary fixed by the 1899 arbitral award if the court rules that the award is valid or that the boundary should be settled in accordance with it? While piously invoking, quote, the law, the question deliberately invites illegal behavior by Venezuela in the event of a judgment in Guyana's favor. The same legal casuistry can be found in the other questions, including especially question 5. How can it be possible for Venezuela to reject the jurisdiction of the court and proceed unilaterally to convert Guyana's Essequibo region into a new Venezuelan state, grant Venezuelan citizenship to the population, carry out an accelerated plan for comprehensive attention to the present and future population, quote, in conformity with the Geneva Agreement and international law? By its referendum and the collective decision and action that are intended to follow it, Venezuela manifests its contempt for, not its conformity, with both the Geneva Agreement and international law. Its intended actions, spelled out in its official communiques and in the public statements of its highest civilian and military officials, are an affront to international law. Venezuela's defiance of the court, its rejection of the court's jurisdiction, and refusal to recognize it as the means of settlement of the present dispute is an affront to the rule of law itself. And its creation of a new Venezuelan state, incorporating the entire Essequibo region, fully usurps the rights claimed by Guyana in these proceedings, which will be irreparably injured, if not completely eviscerated, without the court's protection. In contrast to Venezuela, Guyana has taken no action, nor does it intend to take any action that would disrespect the court or prejudice the rights claimed by Venezuela to the territory at issue in this case. There is nothing that Guyana or British Guyana before it has done in the 124 years it has been administering the territory following the 1899 arbitral award that would prevent it from ceding the territory to Venezuela if the court were to set aside the award and establish a new boundary along the line that Venezuela now claims. nor is there a scintilla of evidence that Guyana would adopt measures irreparably prejudicial to Venezuela's claim during the time until the court issues its final judgment on the merits. The evidence is all to the contrary. It establishes that only one party to these proceedings is acting to the irreparable prejudice of the other's rights, and that the transgressive party is Venezuela. There are thus no grounds for the indication of provisional measures against Guyana or against both parties. If Venezuela were to ask tomorrow for what it might describe as a, quote, balanced order with provisional measures indicated against both parties, Guyana trusts that the court will not be deterred from dispensing justice by such claims of false equivalence. Madam President, members of the court, this completes my presentation. I thank you for your kind courtesy and patient attention. Since I have no other appearances here scheduled before February, I would like to express, if I may, what a privilege and a pleasure it has been for me to appear before you, Madam President, and before Judges Benuna, Robinson, and Gavorgian, many times during your tenures on the court. I congratulate all of you on the completion of your terms and wish you all the very best.
And I now invite the agent of Guyana, His Excellency Mr. Carl B. Greenidge, to take the floor. You have the floor, Excellency.
Thank you, Madam President. Madam President, members of the court, it remains for me to close Guyana's presentation this morning and to read our submissions, which are also set out in the letter I have given to the registrar in 2 originals. On behalf of the Cooperative Republic of Guyana and its legal team, I thank the court, starting with you, Madam President, and all the judges for giving your precious time and attention to Guyana's request for provisional measures and for convening these hearings as promptly as you did. I would also like to express our gratitude to the registrar and his outstanding staff, to the excellent interpreters, and to all the hard-working court personnel who facilitated these hearings and contributed to their efficiency. As always, Guyana places its complete confidence and trust in the court, convinced that the court will deliberate earnestly and respond fairly and justly to the request that Guyana has placed before it. I shall remain available to the court pending your notice of the date for the reading of the court's order. And I will now read Guyana's submissions. For the foregoing reasons, Guyana submits that the court should indicate the following provisional measures which would remain in effect until the issuance of the court's judgment on merits. 1. Venezuela shall not proceed with a consultative referendum planned for 3rd December 2023 in its present form. 2. In particular, Venezuela shall not include the 1st, 3rd, or 5th questions in the consultative referendum. 3. Nor shall Venezuela include within the consultative referendum planned or any other public referendum any question encroaching upon the legal issues to be determined by the court in its judgment on the merits, including, but not limited to, A, the legal validity and binding effect of the 1899 award, the sovereignty over the territory between the Essequibo River and the boundary established by the 1899 award and the 1950 agreement, and the purported creation of the state of Guyana-Essequiba and any associated measures, including granting of Venezuelan citizenship and national identity cards. 4. Venezuela shall not take any actions that are intended to prepare or allow the exercise of sovereignty or de facto control over any territory that was awarded to British Guyana in the 1899 arbitral award. Venezuela shall retain, that's 5, Venezuela shall refrain from any action which might aggravate or extend the dispute before the court or make it more difficult to resolve. 5th, Madam President, members of the court, this concludes Guyana's presentation. It has once again been an honor and a privilege to appear before you. I thank you.
I thank the agent of Guyana, whose statement brings to an end the single round of oral argument of the Cooperative Republic of Guyana, as well as this morning's sitting. The court will meet again tomorrow at 10 a.m. to hear the Bolivarian Republic of Venezuela present its single round of oral argument. The sitting is adjourned.